So, hey, everybody. I want to thank you for joining today. I think we have people from varying areas, so we're looking forward to having you learn about this very important topic, ensuring for your future. We had actually had Britt speak for MusiCares on site, probably back in the fall, I think. It was incredibly well received. So we wanted to bring her back during this tenuous time and provide some education. And I think that it certainly will help everybody feel like they have something within their locus of control. Before I introduce Britt, I also want to let you guys know about two of our support groups. MusiCares has a cyber support group that's happening on Tuesdays and Thursdays. It's for music people just to get together, have some commonality. And we also have weekly recovery support groups that are happening. A place for folks who are in sobriety to come together. They are great groups. All the information is on our social pages, Instagram and Facebook, so take a look. You can also call the New York office if you have any questions. I want to thank Britt and her team for your support and just doing this for us. We're incredibly grateful. So without further ado, let me introduce Britt. Britt Berner joined the firm in March 2014. And since that time, she has been the driving force behind the Manhattan office. Immediately after taking the bar, Britt started working at Dewey and LeBoeuf in Manhattan as a litigation associate, and then became an assistant DA in the Sex Crimes Bureau at the Kings County DA office. Britt then went on to be an associate at a Manhattan firm focusing her practice on elder law and estate planning. For her fifth consecutive year, Minneapolis-based law and politics publishers of Super Lawyers magazine named Britt as Rising Star Attorney. Super Lawyers, published in the New York Times magazine, is a listing of outstanding lawyers from more than 70 practice areas who have attained a high degree of peer recognition and professional achievement in their respective fields. In 2017, Britt received the honor of being named an Outstanding Woman in Law by Hofstra University School of Law Center for Children, Families, and the Law and Long Island Business News. So Britt, thank you so much. And please go ahead.
Yes, thank you so much. I'm sad that I am not in that beautiful church that you guys usually meet in. I love that church, and I usually get choked up when I talk about how much I love it. It's great. My grandfather and grandmother spent a lot of time there. So hopefully we'll be back there again soon and we can meet together there. But for now, this will have to do from my living room to yours. So today we're talking about preparing for uncertainty, basics of estate planning. Really, we're just talking about those basic documents that everybody should be thinking about to figure out if they need them and what they should say. So I'm going to share my screen with you for part of this talk so that you can see just a few of the things that I'm talking about. It's sometimes a little easier to see the list, but I'll go back and forth between you seeing me and seeing the screen. So when we talk about the basics of estate planning, we're talking about very basic estate planning documents that everybody should be thinking about. These are the four main documents when we talk about estate planning. I'm going to talk about a few other things as we go through, but this is really what we're going to be focusing this time on. Healthcare proxy, living will, power of attorney, and last will and testament. And when I get into the last will and testament, I'll talk a bit about the probate process and what that means and what happens if you don't have a last will and testament upon your death. So this is the basic outline for what we're going to be discussing today. So that being said, we are going to start with the healthcare proxy. The healthcare proxy is a document that says who will make your medical decisions if you cannot make them for yourself. So if you are deemed incapacitated by a doctor, who is going to make those decisions. Now, I always explain to people that this could be a temporary incapacity, such as being under anesthesia during surgery and a decision has to be made, or it could be a lot more long-term capacity, such as from dementia, Alzheimer's, or something else that makes it so that you can't speak with your doctors and give informed consent for medical care. And so the healthcare proxy is really important because it says who you want to make those decisions for you. There is a default in the law. It's the Family Healthcare Decisions Act. And the Family Healthcare Decisions Act is one that says that if you're in a facility, so if you're in a hospital or a nursing facility or rehab facility, and you can't make your medical decisions, it says who will be the surrogate decision maker for you. Anyone you've named in your healthcare proxy documents at the top of that list. But the default, if you don't have that, is your spouse. And if not your spouse, then your children. And then it goes down the line of list of people. Now, an interesting thing about that could be a few things. One, what if your spouse has different religious beliefs than you do about certain medical decisions? Or what if your spouse is so attached to you that they wouldn't want to tell the doctors to stop life support when maybe that's what you would want? Or maybe you're worried about the opposite. But it's very important that you have someone named in the healthcare proxy so that you have control at a time where you don't have any control. And Jennifer touched upon this when she started. You know, what we're trying to focus on now, or what are the things we can control when something like this pandemic comes down, and there are a lot of things that we don't have control over. And so making a decision as to who will be there for you to be that surrogate decision maker is really important. I want to just point out before we keep going that at the bottom of your screen, there is a Q&A box. So if you type a question into that box, we will answer it. And Liz from my office is on, and she'll alert me if there's any in there that I don't see and read them out. So if you do have any questions, these are usually pretty interactive when we're in person. So you just type them right into that box and we'll make sure all the questions do get answered. So that's the healthcare proxy. And again, it's who's going to make medical decisions if you're deemed incapacitated by doctor and you cannot make them for yourself. So that's the number one document that we want to make sure people have. It's important to note that you do not need a lawyer to sign that document. You do not need a doctor to sign that document. All you need are two people to be your witnesses, witnessing you signing it, who are over the age of 18, and they are not the people that you're naming in the document. So two unrelated parties uninvolved in the situation who will be the witnesses. You'll sign and date it, and they will sign and put their name and address and date it as well. So that's all you need to sign it. If you have a healthcare proxy, you want to make sure that you do a few things on it. Not only are you naming who makes those decisions, you should name a successor or a backup person. So if the person that you've named is unavailable or unable to act, there's somebody to act in their place. You also want to make sure that if you want your agent to be able to make decisions regarding end-of-life treatments such as artificial nutrition and hydration, that you actually write that into the form and you state that your agent knows your wishes regarding artificial nutrition and hydration and can make those decisions. When I talk about the form, I'm referring to a New York State Department of Health form. So if you were to Google right now, New York State Healthcare Proxy, you would get a PDF would come up on your Google searches, and it would be a multi-page document, the first few pages of which are an explanation of how to properly fill out the form. And then there's actually a 2-page form that is the healthcare proxy form. You don't have to use that form, but certainly if that's something that you're doing on your own, that's the form you're going to want to be using. It gives you a place to name the first person to act, their successor. Then it also asks you the question that I referred to about artificial nutrition and hydration. And it also gives a place where you can say the duration of the document and how long it's in effect for. So for example, I had a client who had a healthcare proxy that named his son to act as his agent, but he was going on a trip for a month and a half with someone who wasn't his son. And he wanted it to be that while he was on that trip, this person that he was traveling with would be able to step in and make medical decisions. So we left the one in place that named his son, but we did a second healthcare proxy with a month and a half long duration. I think we ended up doing a 2-month duration that expired at the end of that time period that said that that person could make those medical decisions during that time. And so for some people, if they're going in for surgery and they want to be clear, this isn't the person that I'm going to want to be my healthcare agent forever, they can say that this is the person that they want to be during that time period. The other thing that you can put on the document is whether or not you want to be an organ or tissue donor. And so that's right there on the second page of that state form where you can put that information. I think we have some questions on this document now, Liz, if you want to pop in and see what they are.
Got it. Someone is asking, this is only for New York law though, correct?
Correct. Everything I'm talking about is New York state law, although something like the healthcare proxy, there are similar laws in other states, but you're going to want to get state specific information. But everything I'm discussing today is New York state specific.
Okay, someone else has a question. Would you recommend a free site or paid legal service site like LegalZoom or Mama Bear legal forms to create end-of-life documents? Also, do you have PDF templates of each of these 4 end-of-life categories?
Okay, so I don't have PDF templates, and the LegalZoom question is always a hard one. I don't know that other one, the Mama Bear. I've never heard of that one. Something like the healthcare proxy, for example, I don't think that you need LegalZoom, and I don't think you need a lawyer. I think you could just go on the New York State Department of Health website and print out their healthcare proxy form and put that in there. So that right there, I don't think you need any of those sites for. What I get nervous with about LegalZoom, especially as we get into conversations about the power of attorney and the last will and testament, is that as an attorney with those documents in particular, I'm more than just drafting a document for a client. There's the legal advice that goes into deciding what to put into the document. And what I find is that when LegalZoom or other similar documents come across my desk that somebody did on their own for a power of attorney and a last will and testament, what I find is that there's normally or almost always an insufficiency in the document that makes it either not valid, or if it's a valid document, it doesn't necessarily achieve the goals the client had because they don't have that advice that goes into it. Especially for New York City residents, I would say that I would look into the New York City Bar Association. They have programs that have attorneys that for pro bono, no fee will assist clients in completing documents. I would also recommend there's other services like NYLAG, NYLAG, that also has attorneys that can assist, or VOLS, VOLS, which is Volunteer Legal Services, and Legal Aid. These are all services that can assist people who don't have the funds to pay for an attorney to assist them with some of those legal documents, can have them done and can get proper advice to make sure that their wishes are actually being achieved.
Thank you, Britt. Where should a person file the completed healthcare proxy to have it be accessible and use it if a person is incapacitated?
Great question. So a healthcare proxy, the good thing about it is that a copy is just as good as an original. So oftentimes when people sign it, they right off the bat make 10 copies. You should certainly keep one in your wallet or your purse or whatever you carry around every day, especially if you're concerned of something happening out of the blue and them not knowing who to contact. I would say that your doctors should all have a copy of it. Anytime you have surgery or you have any kind of medical procedure, you're going to want to give that document to the individuals that are providing it or the institution where you're receiving that procedure. And also in terms of your home, EMTs are trained to look on the back of your front door as well as on your refrigerator for documents like this. And then they can bring it with you to the hospital if they're transporting you to the hospital, and the hospital staff can contact the appropriate person.
How can you get lost copyright back?
I think I need more information, but because of time constraints, I'm going to put up my email address when this is over, and I would say you should email me about that specific, and if I can assist, I will, and if I can't, I'll try and see if there's another resource I can give to discuss that. It's a little, if it's what I think we're discussing, it's a little off the topic.
Thank you. It looks like someone else is sharing a publication form, so I'm going to push that over. You can go to the Q&A, and under the answered questions, everyone will be able to see that. It's a website that someone's sharing.
Oh, they're asking if that's the healthcare proxy form. So let's see if I Google it. I'm going to show you exactly what I'm talking about, because why not, right? Because I can share my screen. So share screen, let's see. I Googled New York healthcare proxy, and this is the first thing that came up is this document. See, now I finally found a benefit to doing this rather than being in person. So this is what I was referring to as the first few pages that refer to how to fill out the document, frequently asked questions, form instructions, and then this is the 2-page form. So this is the first page here, and you'll see that you have who you name, their name, address, and telephone number, an alternate person. This is the part here that talks about artificial nutrition, hydration. This is where you sign it. Then this talks about organ and tissue donation, and then the witness signature. And 1430, that's the same one that was put up by the person who put it in the Q&A. So yes, you had the right document. Any other questions right now, Liz?
I don't have any questions at the moment.
Okay, great. Great. So we'll move on now. That's the healthcare proxy. And next I'm going to move on to the living will. So a living will is a document that states whether or not you would like to be kept alive by artificial means if you were in an irreversible state with no reasonable expectation of recovery. So you can think of this, if you remember back to the 90s, I think it was, with Terry Schiavo down in Florida. It was a very well publicized case where a young woman who got into an accident, and she was in a persistent vegetative state, and her parents wanted to keep her on life support, and her husband's position was that she would not want to live that way, and that she would not want to be on life support indefinitely. And this was the argument that they had back and forth. And if she had had a living will that stated in general terms whether or not she would want that kind of treatment, I don't know that it would have kept them out of court completely, but it certainly would have given the court some information as to her wishes and what she might want in that situation. Obviously, this is a document that's written in so far in advance most of the time of even having a dire medical prognosis, let alone being in that state of no reasonable expectation of recovery, that you can't say exactly what you would want. But what it should do, if written properly, is it should give your agent under the healthcare proxy or the surrogate decision maker under that default law of the Family Healthcare Decisions Act, it should give that surrogate decision maker the right to make those choices and to withdraw or withhold certain treatment if you become in that state. And it often lists different types of treatments like cardiopulmonary resuscitation, which actually in the end ends up being a DNR, a do not resuscitate order that your agent could sign for you, whether you would want certain antibiotics, cancer treatments, kidney dialysis, etc. I think there's some questions, so I'll jump in and answer those.
Yes, while social distancing, how can we get witnesses?
Oh, that is a great question, and I didn't plant it there, but thank you. So right now, the governor, Andrew Cuomo, has signed an executive order that has allowed for remote witnessing during the COVID emergency in New York State. It was just extended to June 7th. So through video conferencing, we do a lot of Zoom calls, certainly in our office, but a witness can, like this, video conference and see you sign the document. You show them your license if you don't already know them, if they're strangers. And if they witness it, and then you either scan an email or fax them back an electronic copy, take a picture with your iPhone and send back an electronic copy that day. On that same day, those witnesses can sign the electronic copy that they received. They print it out or get a copy of it. And then within 30 days, they can actually, if you get them the original, they can sign the original. So it's a little bit of a process, and it does require a little bit of labor, unfortunately, but it's the best we can do right now. So that's how we've been signing documents with clients, is with this video conferencing procedure that the state has put into place.
Thank you, Britt. Next question. Wouldn't the healthcare proxy, husband in that case, be the person to make the call regarding pulling the plug in that scenario?
So I think we get into the, without getting into the legals of what happened in the 90s in Florida in this particular situation, yes, generally speaking, it would be whoever was listed as the agent under the healthcare proxy, and in New York State with no healthcare proxy, in that case, it would have been the husband. I don't think Florida, I don't even think New York had those laws back when this was the case, and I certainly don't think Florida did. But yes, if that was those same set of circumstances now, it would be the spouse who is making the decision. Now, as we know, if somebody's willing to litigate an issue, unfortunately, they can generally find a way to litigate an issue and hold things up. There's also hospital ethics boards that get involved when, if there's a clear-cut intent on the part of the person who can't speak for themselves, it's more likely that their wishes are going to be followed.
Thank you. We don't have any other questions at the moment.
Okay, great. So the living will has the two witnesses just like the healthcare proxy. And you may hear some people say, oh, the living will has no legal weight. And what that really means is it's written very vaguely. It's written as a directive to your agent to generally state what your wishes would be. But it's not incredibly specific because you, at the time you sign it, or usually don't know what your diagnosis might be, what doctors are going to be treating you, how old you're going to be, what the other parts of your life are going to be like, and then also what treatments are available. Things are changing every day. So the living will is meant to be a general statement of your wishes and your intentions. If you are a person who has a more serious diagnosis or a specific diagnosis, then in that case, we tell you to speak with your doctor about signing a MOLST form, M-O-L-S-T. This is actually a physician's orders, and it's signed by both you and your physician. And it says more specifically in what circumstances you would want to be brought to the hospital, in what circumstances you would not, in what circumstances you would want certain treatments or not want certain treatments. And that can really be done as somebody is closer to the end of life so that they can control what happens and have a voice in it when they really know a lot more of the specifics of what's going on. And that's the most form, MOLST. And actually in New York State, it's another Department of Health form. And I believe if you Google it, you can see a draft or a copy of it. But in order for it to be valid, it has to be the original bright hot pink form that your doctor should have. And if you are a Medicare recipient, Medicare actually pays for a doctor's visit for the purposes of filling out the most. And I'm sure most health insurances would have a similar provision in having a doctor fill that out. So that's the healthcare documents. Before I move on, are there any questions about the healthcare end of things before I kind of move on to finances? Okay, it looks like no. So now we're going to be talking about the other two documents, the power of attorney and the last will and testament. First, for the power of attorney, we're talking about a document that is in effect while you are alive. Upon your death, your power of attorney ceases to exist. And so that's a very important thing to realize. The power of attorney document lists individual powers. So you are saying who you want to handle certain functions for you. And these are generally more financial and property related functions as opposed to the healthcare agent who is handling healthcare and medical functions for you. Your power of attorney can give your agent the power to go over banking transactions for you, real estate transactions, changing beneficiaries on accounts. It can be as extensive as allowing your agent to make gifts on your behalf, to create trusts on your behalf, to fund trusts, to apply for government benefits. The Social Security Administration has their own power of attorney situation and they will not accept the power of attorney form. However, it can allow an agent to apply for Medicaid for you, for long-term care services, access a safe deposit box on your behalf, etc. So the agent has the actual powers that are listed in the document. I see we have a question there, Liz, if you want to read that one out.
Sure. Is the living will only related to healthcare decisions, or does it also include decisions on other items, such as real estate, similar to the power of attorney?
So the living will is only referring to end-of-life medical decisions and whether or not you would want certain treatments. So if you're talking about having decisions made by another person over any of your property rights or your assets, you're going to want to have the power of attorney document. The power of attorney document is in effect as soon as you sign it, and the agent can use it as soon as they sign it. So if I am naming my sister as power of attorney, she can't go register that with the bank and act on my accounts and use that document until I've signed it in front of a notary and she has signed it in front of a notary. Again, during this time, the governor has allowed for remote notarization of documents with that same system of video conferencing. And so we've been able to actually notarize powers of attorney for clients during this time as well. The power of attorney document is unfortunately incredibly complicated. It has a standard list of powers that are in a statutory form, but then the document also allows for modifications to be put into place. And these can be anything from the safe deposit box that I was talking about, applying for government benefits, accessing, changing your distributions on a retirement account, any of these things. And so that is one section. And then you can also put on that document that you are signing a statutory gifts rider. Clients get very scared of the word gifts, and I think the governor and the legislature, when they created this document, wanted you to take pause when you saw gifts on that document. But what it's talking about is any transfer of assets out of your name, not paying for goods and services, but uncompensated. So for example, if you have a trust and you want to change ownership of a piece of property you own or of a bank account from your name to your trust's name, but you're not able to do it and you want your power of attorney to do it on your behalf, or your power of attorney has decided that's what's most appropriate, your power of attorney, the agent, needs to have that statutory gifts rider attached to the document in order to be able to make that transfer. So the gifts rider is not necessary for everyone, but it's one of those things that goes in the category of you should have an attorney's advice. And actually, the state's form says right on it that you should have an attorney's advice as to whether or not the gifts rider makes sense in your situation. In order to sign a power of attorney, as I said, you sign it and have it notarized. In order to sign the statutory gifts rider, which is actually attached to the back of the document and has to be signed on the same day at the same time, you would need, again, a notary and then 2 witnesses. And those 2 witnesses, one of which can be the same notary, have to be over the age of 18, not the person you're listing in the document, and have to give that same information as on the healthcare proxy, their name and their address. Liz, I can answer that question that's there now. We lost Liz. Okay, so, sure, go ahead, Liz.
Yep. Is your spouse your power of attorney by default? Is the power of attorney generally for situations where one might not be capable of making sane decisions?
Those are 2 really good questions, so I'll take them one at a time. One, is your spouse power of attorney by default? No. And a lot of people get really confused by this. So just because someone is your spouse doesn't mean they can access your bank accounts, access your retirement accounts, or do any of these things on your behalf, because they are things that are individual to you. Now, obviously, if you own it jointly with your spouse, that's going to be different. They can access it by virtue of that, but your spouse is not automatically your power of attorney. As for whether or not the power of attorney is generally for situations where one is not capable of making sane decisions, that's how we use it quite often, but actually the power of attorney document is created under the general obligations law and was a business document. It was for people who couldn't show up at real estate closings or other business transactions. Somebody could step in and sign off on their behalf. It was then kind of taken over by trust and estates lawyers and elder law attorneys to be used for when people lose capacity. But if you've ever heard the term durable power of attorney, what durable means is that it's in effect now and it remains in effect after I become incapacitated. It used to be that not all powers of attorney were durable. They used to only be in effect if you had capacity. So exactly the opposite of that situation. But now, the way the power of attorney is, it says that all powers of attorney are deemed to be durable unless they specifically state that they are not durable. So we've really flipped that on its head.
Thank you, Britt. Next question. What do you recommend when attorneys advise different things?
That's a really hard one. I mean, I think, I guess I'd say 2 things. One, if you have 2 attorneys that advise 2 totally different things, the first thing I would do is see who you feel most comfortable with and who you feel that you trust and feels most aligned with your situation. A lot of the questions that people ask me, if 2 different people ask me the same question, I would answer it totally differently based on the person's individual situation. So I think you want to make sure that whatever attorney is advising you or you're discussing things with really understands your situation and understands what's important to you and what's going to be most applicable to you. Now, if you feel both attorneys are in line with that, I mean, I guess you could get a 3rd attorney to be the tiebreaker, but usually you can find and trust your gut that there's one that might be more appropriate for your situation, and go with the person you feel most comfortable with, I would say. Okay, so that's the power of attorney document. And next, we're going to be talking about a last will and testament. So a last will and testament is a document that says your wishes for after your death. So realize, until now, we've been talking about your wishes and how things are handled while you're still alive. Your last will and testament isn't taking over until after your death. You can name who you would want to be your executor, which is the person who will handle the collection and distribution of your assets and the payment of your final bills and expenses. And you can also choose how your assets are distributed. You can do what we call our specific bequests, such as I give my ring to my niece, or I give $5,000 to each of my grandchildren. And then you can also have and should have what we call a residuary clause, which is percentages. So then, if I may give my ring to my niece, but everything else divide up into, 5 shares, 20% each to these 5 people. And you can also say if you want those people to get the assets outright or in some kind of a trust structure, and lay out the terms of that. I think we have some questions right off the bat, so I'll answer those before I keep going.
Perfect. Are there circumstances under which a last will and testament are not binding?
So I would say that a last will and testament has to go through the probate process, which is the next thing I'm going to talk about. And I think that your answer will be apparent once I go into that. But as long as a will is deemed valid after the probate process, then it is binding. It's only if it doesn't meet the level of the court believing that it's a valid document that it could not be binding. And I will go through what that probate process is in a minute once I get through these other questions, and I think that will become clear.
Thank you. Someone is asking if the webinar will be rewatchable, and yes, it is being recorded and will be uploaded on our website. Correct. Britt, yep, at
that's great.
burnerlaw.com.
Right. And Jennifer, if you in any way want to use it, or we can send it to you as well. I don't know if you guys have a way of doing that, but we will put it on burnerlaw.com.
Absolutely. Next question. Can witnesses of a will be beneficiaries or executors of that will? I.e., if I want to use my brother, but he is listed as a guardian, also can a witness also be the notary? So a few questions in one.
I would say no. I would say your witnesses should be people that are totally outside of your beneficiaries and any agents you're choosing. I would have to go back to read how the statute reads exactly. I think it's something along the lines of if anybody is going to be benefiting from the document. But beyond that, yeah, I would say anyone that you're naming in a position to hold a fiduciary position, trustee, will, executor, or guardian, you're not going to want to have that person or a beneficiary be your witness. But a will, we didn't discuss this yet, but a will to be valid needs 2 witnesses. We then usually have those 2 witnesses sign an affidavit, which is subsequently notarized, saying that you are of sound mind over the age of 18 and the other things that are necessary for signing a will. That's what makes a will what we call self-proving. But to actually have a valid will, you only need 2 witnesses. And then if those witnesses don't sign the affidavit, that's something that after your death, when your will is probated, those witnesses will be called upon to attest to those same things of your ability to sign the will. So we talked about what goes in a will. We talked about how you sign a will. So what actually happens when someone dies? So the first thing that's incredibly important to realize is that a will is only, I'll say, dealt with, but really the answer is it only goes through probate, the process of probate, if you have assets in your sole name with no beneficiary. So I'm going to give you an example. If you have, you rent your apartment, you have a checking account with, let's say $6,000 in it, or 10, let's say 10, that's a round number, right? So $10,000 in your checking account. and you have a small retirement account, maybe $20,000 that names your sister as beneficiary. That retirement account is going to go to your sister. She is going to fill out forms with the institution that holds the retirement account, the IRA, 401k, whatever it is, and she's going to get that money. Even if your will said, give my retirement account to my brother, because your sister is listed as a beneficiary with that institution on that retirement account, she is going to get that money regardless of what your will says. Your checking account, though, has just your name on it, has no beneficiary. Your will is going to have to go through the probate process so that the court can appoint an executor who can then be in charge of distributing that $10,000 the way you've decided it should be distributed to the appropriate beneficiary. Without the probate process, if your executor, your named executor that you've chosen, goes to the bank and tries to collect that $10,000, they're going to be told by the bank, we cannot release this to you unless you have letters from the court. Letters testamentary, that's what appoints the executor. And that's what lets the bank know that it's okay to give that money to the executor. Because think of it this way, what if the executor went, got the money, and gave it to whomever they chose, or gave it to the person named in the will, but it turned out that a year after you signed that will, you had actually signed another will, and nobody knew. You didn't tell the executor that you signed a new will. You didn't tell the executor that you not only assigned a different executor, but you also changed where the $10,000 was supposed to go. So the probate process is supposed to make sure that your will that is validated is actually your last will and testament. It's actually the last one that you've signed and that it's valid. With that, I'm going to explain what the probate process is. So you can't have probate without a will, and you won't follow the terms of a will after death without probate. They go hand in hand, and you can't have one without the other. If you don't have a will, there's a process called administration, which is very similar to probate, but it's a little different, and I'll discuss that in a minute. So with the probate process, the court says, okay, I'm going to give an example. Say you have someone, I die, and I leave everything to MusiCares Foundation. Everything is going to MusiCares 100%, and my sister is my executor. When my will is brought by my executor or the attorney that they've hired to do it, and a petition is brought to probate my will, my sister, I have 6 siblings, all 6 of my siblings are going to get a notice saying that my will is being probated. It's going to give them a copy of the will, that it's all going to MusiCares, and they'll have an ability to contest that will if they think I wasn't of sound mind, or it wasn't my signature, it was somebody else who signed it, or some other reason that my will is not valid. And my next of kin are going to be able to make that determination. So in my case, actually, it wouldn't be my siblings. I'm unmarried. My parents are still alive. My parents are my legal next of kin. So my mother and my father would get notice that my will was being probated, and they would be able to contest it. Assuming that they're very happy for everything to go to MusiCares, they'll sign waivers, or they'll default on the citation that says they can contest. My will go through probate fairly quickly. My sister will collect the money. She'll pay my expenses and my debts, and she'll give the money to MusiCares. Where this becomes an issue is people who are disinheriting their next of kin, and the next of kin are not happy about it. If my parents were very upset that I was giving the money to MusiCares, or if the people who are my legal next of kin can't be located. So I have plenty of people come in and say, I want to do a will, but don't worry, it's really simple. I'm not married, I have no children, my parents are deceased, I'm an only child, my parents were only children, so I don't have cousins, I don't even know who my cousins are, so don't worry, I have none, it's going to be really easy. That's actually really hard, because that's going to be someone where probate is very time consuming and costly, because we have to find those next of kin, whoever they are. They could be, 12 cousins, and they could be in a totally different country, but the court's going to make us try and find them, try and figure out who they are, try and locate them and give them notice that this will is being probated. So you want to really be smart about whether or not probate is going to make sense in your situation. Okay, so in terms of probate, so we discussed if I have a joint owner on an account or on a property, there's not going to be probate of that property, and if I have a beneficiary designation. But let's say everything I have is just in my name, I've never named a beneficiary, then that's when I'm going to go through that probate process. Now, if I don't have a will and everything's in my sole name, there's going to be what's called an administration process. And the difference is that you're still going to have to give notice to all of those legal next of kin, but the court gives priority based on closeness of family relation to who can be the administrator of your estate, which is the same thing as the executor of a will. It's somebody who handles the estate. And also the court's going to determine where the assets go. So if everything's in my name, it's in my situation, my legal next of kin or my mother and father, they're going to get everything 50-50. They will get everything half and half. Now I have to think about that. If I don't have a will, do I want my parents to get everything? Maybe my parents are on government benefits. Are they on Medicaid? Are they going to get kicked off their Medicaid if they receive the assets? Maybe they should be getting them in a trust. Maybe they should be protected. Maybe I should bypass my parents and give them to a different family member, like a sibling or a cousin, or to a charity, because that's going to be better. Or maybe I'm very happy for them to go to my parents. But these are all the types of things. When earlier I discussed why I don't like when people go online and do these documents, it's the kind of things that are very hard to think of in your own situation. And when you sit with a lawyer and they advise you as to the best way to dispose of your assets so that they'll be disposed of the way you want them to be, these are the things that we're talking about. I can answer the question that's there now, Liz.
You got it. I had a will drawn up by an attorney. I wanted to change it a few years ago without using a lawyer. I kept to the basic template and made the changes, got it witnessed by 2 people and notarized. Since the second will wasn't drawn up by a lawyer, will that cause problems in probate? Also, I own a rental property that is in contract and will be sold in 2 weeks. In my current will, the apartment is going to my daughter. Do I have to change my will since I will no longer own the apartment soon?
I'm going to handle the second question first, but Liz, just hold that question up there in case I need to get it more. Okay, so the second part, no, you don't have to change your will. So generally speaking, if you have a property that you say, you know, I give 123 Main Street to my daughter, and upon your death, you don't own 123 Main Street, that will normally what we call a deem. So that gift will just go away because you don't own the property. So you, assuming that your will is written in that way, then you don't have to worry about that. The first question about rewriting your own will. So the main thing about having a will drawn up by and the execution witnessed by an attorney is that when a will is drawn up by an attorney and when an attorney oversees the execution of the document, there is a presumption, a legal presumption, so the law actually says this, that is a valid will. What that means is you start up here, this will is valid, and somebody's got to prove that the will fails. If you don't have that legal presumption of validity because the attorney wasn't overseeing the execution, you start down here and you've got to prove the will is valid. And that can be an uphill battle. You might not be able to find those witnesses at the time that the will is probated at your death. You don't know where those witnesses will be. Maybe they'll predecease you. And so I usually recommend that an attorney be involved for that purpose, especially with a last will and testament, because you want to start at the top of the mountain. You don't want to have to be fighting your way up. And it's not you fighting your way up, it's whoever you've left behind because you're not around anymore, presumably, if we are probating your will. I think I got those, Liz. We can
You
go
did,
on to
thank
the
you,
next.
yes. Next question, are copies of wills valid or do you need to sign multiple original copies? Also, what's the rough legal cost for creation of a will in New York?
Okay. Copies are not the same. So the statute says that a will, the original has to be the document that is submitted to the court for probate. I wouldn't suggest signing multiple originals because every will is your last will and testament. And so if you sign 4, how do you prove which one was the last one? So if you sign 4 duplicates. So every will is your last will and testament, and your last will is the one that actually they all say this will revokes any prior will. So I wouldn't sign multiple. You want to make sure that you keep the original in a safe place. You don't ever want to unstaple it because the court actually checks to make sure it wasn't unstapled and that multiple pages weren't slid in to change your wishes. So you want to make sure that original will is kept in a safe place. As for cost, I cannot tell you the cost in New York State. I will tell you that in our office, if we're going to do a last will and testament, we're usually also doing a power of attorney and the other documents. And depending on the situation, standardly, I would say it starts around $1,500 for the will, power of attorney, and other documents, although I've charged less and I've charged more, but just to give you an idea. I want to just say one more thing about that too. I also know other attorneys who don't practice in this area of the law, and they don't know the ins and outs of all this probate the way we're discussing it. And so I would just make sure that when you are meeting with whatever lawyer you're meeting with to do a will, that they're discussing all these different things with you. That's why a webinar like this is great for you to learn what kind of questions the attorney should be asking, because you want to make sure that you're meeting with someone who's knowledgeable, not just about filling out a form and writing a document, but also what the practical implications of the things that you've written are going to be.
Thank you, Britt. There's no additional sorry, spoke too soon.
Okay.
I'd like clarification regarding the last will and someone listed as a beneficiary on financial accounts.
Okay. So I think what you're referring to is when I was talking about how if my IRA lists my sister as beneficiary, but my last will and testament says that my IRA should go to my brother, the beneficiary designation that names my sister that's on file with the institution that holds my IRA is going to win out. That is going to be the document or the person who receives that asset. It is the superior document when it comes to beneficiary designations. I think that answers that question. And please write in if I didn't answer it and you have another question.
Yes, that answers that question.
Great.
We've got one more question here.
Okay.
Does putting assets into a trust somehow avoid immediate taxes? You mentioned not wanting to saddle parents with issues if assets are granted to them. Just wanted to better understand if in a trust, the executor makes decisions.
So the trustee of a trust is the person in charge of those assets. What a trustee can do and what the tax implications, if any, of that trust are going to depend on what the type of trust is and how it's drafted. So I always tell people that if you want to know the answer to how a power of attorney should act, or an executor should act, or a trustee should act, the first thing you need to go is go to the document that empowers that person and read the rules of the game. So if the trustee's actions are governed by that trust document, that's going to be the first place you start. Now, for certain things, there will be defaults in the law that you go back and say, does a trustee have this power or that power? But for the most part, it's going to be the actual document that controls. That's why you shouldn't give your attorney a hard time when you say there's a lot of boilerplate in a document, because a lot of that is in there so that the trustee or the executor or the power of attorney knows what to do, knows how to act. That's the purpose for those documents being so lengthy and wordy.
Did you have any? Oh, I apologize. One more. I have a daughter and just finished a divorce trial. We have a STIP, but it hasn't gone through yet. If I have not yet created a will, but it says in the doc that our money will go to our executor for our daughter, is this enforceable?
It's enforceable, but it's interesting. I did a webinar last week with a family law attorney, two women who are family law attorneys, specifically about estate planning after divorce. And what I would say is that once your divorce is finalized, I would do a last will and testament that is in line with the stipulation that you've come to, and make sure that the terms of your stipulation and the things that you're required to do are actually written down in a signed valid will, so that so it will be continued, and so that those things will be followed. It will avoid litigation down the line after your death. Are there any other questions, Liz?
If a family member dies owning money to a condo association, are the heirs responsible for debts?
So heirs are not responsible for the debts of a deceased person, except to the extent that they're inheriting money. So if there's $10,000 in the estate and somebody owes an $8,000 bill, that creditor is going to have to be paid back before the assets are distributed to the beneficiaries. But if there is no money, if somebody dies penniless and they have debts, those debts will die along with them. Okay, I don't think we have any other questions. Well, actually, I'm looking at my outline here, and that was the last thing that I was going to discuss. So I promised I'd give my email, and so I'm going to give that now, and I'm happy to just wait a minute and answer any other questions that come up. But this is my email address. So you guys can see that. I know I had said somebody should ask a question earlier. I'm happy to try and help to the extent that I can. And I really want to thank MusiCares for having me speak to you all, and to Jennifer, and I really appreciate it.
Thank you, Britt, so much. I think everybody's leaving armed with some incredible, valuable information, education. So thank you so much.
My pleasure.